who state that they saw the accused person commit the crime. Circumstantial evidence, on the other hand, is evidence from the surrounding circumstances of the case. The circumstances must be such that they point to nothing else than the guilt of the accused person. Prosecution adduced the evidence of Phoebe Namutebi, PW6, and Aneta Goye Odong, PW7, who testified that they saw Okello or Onyum Christopher, the accused person, cutting the 4 children inside the premises of Gaba Early Childhood Development Center on the 2nd of April 2026 at about 11 a.m. or thereabout with a knife. Esserite James PW15, the divisional CID officer of Kabalagala, and the Soko scenes of crimes officer responded and found when the accused had been arrested within the premises by Cyrus and Moses, security guard who was at the church gate. The accused was detained in the guard house of Gaba Early Childhood Development Center to keep him away from the angry mob that had gathered, and they rearrested him. There was DNA evidence, also PW17, which revealed that the DNA of the accused person was actually found on the hand of the knife, which was recovered behind the scene. And both the report and the knife were admitted. There was also the DNA evidence also found some of the DNA from the bodies of the children on the clothes of the accused person. I will talk about contradictions and inconsistencies. There may be contradictions and inconsistencies in prosecution evidence. There are those contradictions and inconsistencies which are minor, and those should be ignored. However, if there are grave contradictions and inconsistencies that go to the root of the matter, those ones will lead to the discrediting of the evidence, and it will not be relied on. I will now turn to the defense case. The defense of the accused person must be weighed against the prosecution's evidence. In this case, the accused gave an unsworn statement and called 2 witnesses in his defense, DW2 and DW3. The accused did not expressly deny causing the deaths of the 4 children, but he repeatedly stated that he did not do so intentionally or deliberately. Although his evidence was lengthy, it may be summarized as follows. He did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected that could have contributed to the death of their children. He said he was not mentally okay. He also denied being forward-minded in the killing of the children. In respect to this, he made reference to the book about the war, which was part of the evidence of PW18, who analyzed his flash disk and found that he had saved a book entitled Sun Tzu on the Art of War. He said that that book or file was saved long ago, and it cannot be said to apply to the killing of the children. He also denied being deliberate and with forethought while making reference to the evidence of the searches he made using his phone, as testified by PW18, and specifically the search for ISIS beheading and for schools that teach young children. He said that whereas these searches suggest that he did it deliberately, but other factors were forcing him to make those searches. He further stated that he was under the control of some people whom he said were in 3 categories. And the accused person further stated that between January to March, he entered into an especially distressing period because he was contending with some people who were surveilling him, made many demands from him, and they threatened to kill him. They began demanding for money, and he notes that they had all the capabilities, and they were following him closely. As a result, he left the neighborhood of Bunga, where he was staying, and started sleeping on the streets. He stated that as a result of this, he tried to end it some way and somehow, and tried a few things to bring the whole thing to an end. He tried to flee the country, he tried to rob a bank, and also tried to kill his brother's family. He then said those people whom he at times referred to as his friends during his testimony had to do with his actions of the second. He stated that court should not honor the charges for murder because there were some circumstances that forced him to act the way he did on 2nd. That is the day of the incident. The accused also kept on denying the claim that he caused the deaths of the 4 children for human sacrifice, and insisted many times that he was coerced to make those statements. However, you will recall that the plain and the charge and caution statements were never brought as prosecution evidence. You will also realize that some of his statements would have required some more explanation from him, but because he gave an unsworn statement, he had to give his story uninterrupted and without assistance from his lawyers. From the above evidence of the accused person and from some of the questions during cross-examination of some of the prosecution witnesses, the accused seems to raise a defense of insanity and or diminished responsibility. The law presumes sanity under Section 10 of the Penal Code Act. It provides that, and I quote, "Every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question, until the contrary is proved." Earlier alone, you heard the prosecutor saying this. Every person, all of us here are presumed to be sane until the contrary is proved. Section 11 of the Penal Code Act provides that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind, incapable of understanding what he or she is doing, or of knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. And diminished responsibility is defined in section 177 and subsection 1 of the Penal Code Act, which provides that where a person is found guilty of murder or being a party to the murder of another, and the court is satisfied that the person was suffering from such abnormality of the mind, whether arising from a condition of arrested or retarded development of mind, or any inherent causes or induced by disease or injury, has substantially impaired his or her mental responsibility for his or her acts and omissions in doing or being party to the murder, the court shall make a special finding to the effect that the accused person was guilty of murder, but with diminished responsibility. Subsection 2 thereof provides that on a charge of murder, it shall be for the defense to prove that the person charged was suffering from an abnormality of mind, as is mentioned in subsection 1. You will also be expected to review the evidence regarding the lifestyle, the conduct, and or behavior of the accused person before the incident on April 2nd, 2026. This evidence can be found in the testimonies of his 2 landlords, one in Bunga, that is PW9, and another in Chanja, PW10. It can also be found in the testimony of PW8, the car rental, the person who gave him or hired to him the car. The vehicle, you looked at the vehicle, you know the registration number. The officer who analyzed the CCTV footage, PW18 who analyzed the accused person's electronic gadgets, Ms. Namtevi Phoebe, PW6, who interacted with the accused on the 1st and then on the 2nd of April. Also Ms. Annette Odong, who interacted with the accused person very closely a few minutes before the attack. You may also consider for your guidance evidence of 2 doctors, Dr. Roger Agenda of CCare IHK Kampala, who made a psychiatric and mental examination of the accused person on the 30th of December 2025 at the request of the accused person. And then evidence of Dr. Emmanuel Nwamanya, PW11, who is a police surgeon but at the same time a psychiatrist, who did a mental examination of the accused on the 7th of April 2026. Ladies and gentlemen assessors, you had the opportunity to listen to all the prosecution witnesses. You also listened to the defense evidence. You should be able to form your opinion in light of the legal principles that I have explained above, and advise the court on whether you believe that the prosecution's evidence adduced has proved the case against the accused person beyond reasonable doubt in light of the defense that he has raised. If you find that the prosecution has proved its case against the accused person beyond reasonable doubt on all counts, You will advise me to find the accused person guilty of the offense of murder on all counts, and you will advise me to convict him as indicted. If, in your opinion, the prosecution has proved some counts and failed to prove others, you will advise me to convict on those proved and acquit on those unproved. However, if you find that from the evidence of the prosecution, analyzed with the defense evidence, there is reasonable doubt, that doubt should be resolved in favor of the accused person. If, in your opinion, the accused person was insane or of unsound mind at the time he caused the death of the 4 children, you will advise me to acquit him because insanity is a total defense. But yes, that is it. And I want to hear from you. How much time do you need to give me your opinion?
You will check today? This evening?
How much time do you need?
10 minutes, my lord.
That will determine whether we are doing it today or we are doing it tomorrow or another day.
10 minutes, my lord.
10 minutes are enough?
Yes, my lord.
Okay, so we are breaking off for 10 minutes and we shall come back to hear from the assessors.
Tugenda umulamu eddakiika 10 tukomewo tuwulirize baseesa.